Welcome to your study guide for the Tennessee Affiliate Broker exam. This covers the state portion, Tennessee law and commission rules on licensing and discipline. In this video, we'll cover the commission and its power, who needs a license, who's exempt, what the commission cannot do, how complaints and hearings unfold, the grounds for discipline, the education and recovery account. Now, don't forget that our website is packed with free exam guides and practice questions, all designed to help you ace this exam with confidence. You'll find the link right down in the description below, so go ahead and check it out. Study smarter, not harder, everyone. All right, let's get started. So, why does Tennessee regulate real estate at all? Buying a home is the biggest financial moment in most people's lives, and they hand near strangers their money and keys. The state steps in under its police power, its authority to protect the public's health, safety, and welfare. Your license then is a privilege, never a right. Keep two dates straight because the test loves to swap them. The commission itself was created in 1951. The governing statute, though, is the Tennessee Real Estate Broker License Act of 1973. The commission sits inside the Department of Commerce and Insurance in Nashville. Asked when it began, answer 51. Now picture the board. There are 9 members and the governor appoints everyone. Tennessee splits into 3 grand divisions, East, Middle, and West, and 3 commissioners come from each, so no region dominates. Each serves a 5-year term with no reappointment beyond 1 full term. Lock in that 9 and 3 per division. But not all 9 are insiders. 7 members must have worked as a licensed Tennessee broker or affiliate broker for at least 5 years. The other 2 are public members, everyday consumers who keep the board honest. Tennessee is strict here. A public member cannot be in brokerage, financing, or development. A mortgage banker will not qualify. Once seated, the members elect their own chair and vice chair, and a majority forms a quorum, so 5 of the 9 must appear to act. Every meeting follows Tennessee's Open Meetings Act, so business happens in public. And note this, the law calls the commission a judicial body, shielding members for good faith acts. 9 part-time citizens cannot run everything, so the law adds staff, and one detail is a favorite trap. The executive director, not the commissioners, must have passed the Tennessee Brokers exam and keeps the commission's seal. There is also a full-time education director and a general counsel. Watch who had to pass that broker exam. What can this commission do? Think of 3 verbs. Make rules, enforce the law, impose discipline. It writes the rules every later exam topic depends on, licenses applicants, sets fees, investigates, and runs education. And here is the funding twist. The commission lives on license fees, not tax dollars. Licensees pay for their own regulator. Now the power the commission deliberately lacks, tested constantly. It can never set, suggest, approve, or publish commission rates. The prohibition has teeth. If rate setting ever happened through commission action, every member would forfeit their license. So any answer where the commission approves a fee schedule or names a customary rate is wrong. Rates are privately negotiated. Everything we just covered about the commission is exactly the kind of material in our free practice question bank. And these are not shallow questions. They are written to test the deep understanding the real Tennessee exam demands with the same tricky distractors. Go try a few and watch how fast these facts start sticking. Let us move to who needs a license. Tennessee law makes it unlawful to conduct, advertise, or even claim to be conducting brokerage without the right license, directly or indirectly. Notice that word claim. Just holding yourself out, a sign, a website, a post offering to sell others' homes triggers the requirement before any deal closes. But what counts as brokerage? Two elements must both appear. You are acting for another and doing it for compensation, or expecting it. Remove either and you fall outside the law. An owner selling her own land acts for herself. Add both though, and even property management needs a license since it means collecting rent for others. How much unlicensed activity breaks the law? Just one act. Tennessee's single act rule says one brokerage act for another expecting payment makes you a broker, and that loan act is a violation. There is no hobby exception. Picture unlicensed Trey in Murfreesboro paid to find a buyer. The moment he lists that house, he has violated the act. The commission licenses more than salespeople. There are brokers, affiliate brokers like you are becoming, and separately the firm itself. Add timeshare salespeople, acquisition agents, rental location agents, and vacation lodging services. Here is a classic trap. Every office needs its own firm license, even a broker working alone from home. The individual license is never enough. Firms also hire unlicensed assistants, so where is the line? Unlicensed staff handle clerical tasks under supervision, answering phones, placing signs, even depositing earnest money under the broker's direct supervision. But the moment they show a home, host an open house, discuss a listing with outsiders, or negotiate, they have crossed into licensed work. The brightest line is pay. Why does pay matter? Because compensation tied to transactions is itself a marker of licensed activity. An unlicensed assistant must earn a wage or salary, never a bonus per closing. The instant a firm pays someone per contract closed, that firm breaks the law and the principal broker who allowed it faces discipline. Keep transaction pay for licensees only. Now, the heart of this topic, the 6 exemptions, people the License Act simply does not cover. First, owners selling or leasing their own property. Second, an attorney in fact under a recorded power of attorney. Third, an attorney at law but only while acting as an attorney. The moment any of them brokers someone else's property for a fee, the exemption vanishes. The last 3 exemptions reward careful reading. Fourth, court-connected fiduciaries, receivers, executors, bankruptcy trustees, guardians acting under a court order. Fifth, resident managers of rental property who may show, lease, and collect, but may never negotiate rents or terms. Sixth, a corporation acting through an authorized officer for its own property, but a limited liability company never qualifies. Here is how I would keep the exemption straight under pressure. Run the list: owner, attorney in fact, attorney at law, fiduciary, resident manager, corporate officer, then hunt for the trap. Did the resident manager negotiate? Was the officer paid per deal? Was it a limited liability company instead of a corporation? Find the operative fact. I know we are moving through a lot of detail, and you might wonder how to make it stick. That is exactly why those free practice questions exist. They turn these rules about licensing and exemptions into real scenario questions. The same style you will face on test day. Working through them makes this knowledge automatic. Let us talk about what students get wrong, the limits of the Commission's power. The key idea: the Commission regulates conduct but does not referee money. It is a licensing agency, not a court. It can discipline your license and fine you, with penalties paid to the state, but it cannot order one private party to pay another. Here is the most tested limit. The Commission will not act as a collection agency for pay fights. Its rule says plainly, it will not intervene in disputes over debts, draws, or commissions between firms, brokers, and affiliates. So when a split goes unpaid, or 2 firms claim one deal, the Commission steps back. Those fights belong in court. What about a consumer who feels cheated and files a complaint expecting a check? This surprises people. No outcome, not even revocation, puts a single dollar in that consumer's pocket. The fines the commission collects go to the state. The consumer's real path is to sue, win a judgment, and collect. Only a court awards damages. The commission also cannot practice law. It will not give legal advice, draft your contract language, or decide what a purchase agreement means between buyer and seller. A disputed earnest money deposit is a question for the parties and the courts. It also does not set a firm's agency policy, nor write the industry's contract forms. Some disputes fall outside the commission because of who is involved. It does not license buyers, sellers, or for sale by owner homeowners, so it cannot discipline them. Complaints about inspectors, appraisers, or lenders go to their own regulators, and discrimination runs two tracks. The licensee's licensed answers to the commission, but the victim's remedies run through fair housing enforcers and courts. One more boundary trips up new agents. Many licensees join the Realtor Association, whose code of ethics is enforced privately by its own panels. That membership discipline is separate from your state license. The one crossover, calling yourself a realtor when you are not a member, is misleading advertising and that the commission can punish. If these jurisdiction limits feel slippery right now, do not worry. That is completely normal. This is exactly the distinction the practice questions drill, with scenario after scenario asking which forum handles the problem. Work through enough, and sorting commission matters from court matters becomes second nature. They are free, so put them to work. Now let us walk the discipline road from start to finish. Who can file a complaint against a licensee? Anyone. A buyer, seller, tenant, neighbor, even a competing agent. There is no requirement you were harmed or part of the deal. The complaint should be written and verified, meaning sworn, and the commission can also act on its own motion. But complaints cannot reach back forever. The everyday deadline is 2 years, measured from when the violation happened or from when the complainant actually discovered it, whichever gives them longer. If the conduct is also a crime, longer criminal timelines can apply. For most questions, anchor on that 2-year window from the violation or discovery. Once a complaint arrives, due process begins. The commission notifies the licensee in writing, encloses a copy, and notifies the principal broker too. Then comes the deadline every Tennessee licensee should memorize. You have 10 days to file your answer. Extensions are available, but here is the trap. Ignoring a complaint is itself a separate violation. How does that notice reach you? By personal delivery or first-class mail to your last known business address, with the clock starting at the postmark. So keep your address current. Picture Marisol in Knoxville accused of failing to deliver a contract copy. Even if the charge is weak, ignoring the letter hands the commission a fresh violation. After your answer arrives, the file goes to legal counsel, who reviews everything to decide whether the facts show a violation. Investigators can dig deeper. And for money cases, remember a sharp rule. The regulatory board's director may examine and copy a licensee's escrow records at all reasonable hours. Refusing that access is itself grounds for revocation. The commission then votes in a public meeting, and 3 roads lead out. It can dismiss, with letters to both sides. It can offer a consent order, the most common route, or send the case to a formal hearing. A consent order is a negotiated settlement. You sign, pay, maybe take education, and get 15 days to decide. Reject the consent order and you head to a formal hearing, a contested case under the Uniform Administrative Procedures Act. An administrative law judge presides. The state must prove its case on the record, and you can appear with counsel, call witnesses, and cross-examine. Lock in this number. A majority of the commission, 5 of 9, can suspend or revoke. What if you lose? You are not out of options. A licensee hit with a final order can petition the courts for judicial review, but that is not a fresh trial. The court only checks the record for legal error. And one more thing, all of this is public, published monthly in a disciplinary action report. Remember, knowing this process and recalling it under exam pressure are different skills. The free practice questions bridge that gap. They throw the 10-day answer, the 15-day consent order, and the majority vote at you until the numbers are reflexes. Take a few minutes with them between these sections and you will feel the difference. Now to the substance of discipline. Start with the toolbox. The Commission can refuse a license, reprimand, suspend, or revoke, and order educational probation. And here is a uniquely Tennessee sanction. It can downgrade a broker back to affiliate broker status. That demotion shows up more than you would expect, so do not overlook it. Then there are civil penalties, and the numbers matter. The Commission can assess up to $1,000 for each separate violation. Notice that phrase, each separate violation, because it is a multiplier, and each day a violation continues can count again. So an unlicensed manager handling 25 units faces $25,000, not one fine. At the center sits the grounds statute, a list marketed as the 21 ways to lose your license. Do not memorize 21 items cold, group them. The first theme is dishonesty with the public, willful misrepresentation, false promises you cannot keep. A continued course of deception and misleading advertising, including calling yourself a realtor when you are not. The second theme is other people's money and records, where licensees get in the deepest trouble. You must account for and remit money belonging to others. That earnest money is never yours. An affiliate hands trust money to the broker immediately. Keep records 3 years from closing. Commingling is mixing client funds with yours. Conversion is spending them. Theme 3 is consent and contract hygiene. You cannot act for more than one party without the written consent of everyone you represent. You must hand-sign copies to all parties at the moment of execution, not next week. Every listing needs a definite termination date, and never maliciously talk a client into breaking a contract to substitute your own. The remaining themes come fast. On compensation, an affiliate accepts pay only from their own broker, and all commissions and rebates must be disclosed. On crimes and discrimination, fraud convictions, and fair housing, violations are grounds. On the system itself, violating any rule or order counts, and so does a broker's failure to adequately supervise. 2 supervision details earn points. A broker is not automatically guilty just because an affiliate misbehaved. The broker answers for their own failure to supervise. Round out the list with the unauthorized practice of law, a broad catch-all for any dishonest dealing the other grounds missed, and Timeshare Act violations. 21 grounds, 7 memorable themes. One ground carries its own engine, and the exam loves it. When a licensee is convicted of or pleads guilty or no contest to a listed fraud-type crime, they must notify the Commission within 60 days. Then the default runs by itself. The license is automatically revoked 60 days after conviction, unless the licensee requests a hearing. Let me make this concrete with a Memphis broker named Walt. He runs 40 affiliates with no written policies and never reviews their ads. One affiliate runs misleading ads and sits on a buyer's deposit. The Commission charges that affiliate and charges Walt separately for failing to supervise. His defense that he did not know is the violation. As we move into our final topic, keep this in mind. Understanding these grounds is one thing, but recognizing them inside a tricky scenario is the real exam skill. That is where the free practice questions shine, turning these 21 grounds into situational questions you will actually see. They are free. Built for this Tennessee exam. Our final topic is the Education and Recovery Account, the safety net for wrong consumers. Remember, the Commission cannot award damages. This account is the legislature's partial answer. It compensates members of the public who have been adjudged to have suffered damages from a licensee's violation. That word adjudged is everything. It pays only on a court judgment. Who funds it? Licensees do, because the industry pays to protect its customers. 3 numbers matter. Every original applicant pays $1 into the account on top of the license fee. If the balance runs low, a renewal assessment of up to $30 can apply, and the account must hold a minimum balance of $500,000. When the account pays out, strict caps apply, tested with precision. The maximum for any single transaction is $15,000, no matter how many victims or parcels are involved. The lifetime aggregate for any one licensee is $30,000, then liability ends, and it pays only compensatory damages, never interest, court costs, or punitive damages. Let me show you the caps in action. Say 4 family members jointly win a $48,000 judgment over one fraudulent lake lot sale near Cookville and cannot collect. The account's exposure for that one transaction is $15,000 total split among them, not $15,000 each. One transaction, one cap. That ceiling catches many students. Who can actually claim? A consumer holding a valid uncollectible court judgment against a licensee. And just as important, who cannot? A licensee acting as an agent in the deal cannot claim. So an affiliate suing their broker over a commission is shut out. A bonding company cannot claim either, and nobody who skipped court qualifies. The claim procedure rewards diligence. When you file the lawsuit, you must promptly notify the commission by certified mail. You win a valid judgment, then you wait until it is still unpaid 60 days, after all appeals end and remedies are exhausted. Finally, you apply to the court that rendered the judgment and it orders payment. And what happens to the licensee whose conduct drained the fund? It is a career landmine. Their license faces suspension or revocation, and they cannot get any new license until they repay the account in full, plus interest. On top of that, the commission is subrogated, stepping into the victim's shoes to recover every dollar it paid. Let us bring it all together. You now understand the Tennessee Real Estate Commission. 9 governor-appointed members protecting the public and writing the rules, but never setting your commission rate. You know who needs a license, the reach of brokerage, and the 6 exemptions with their traps. And you can map its power, conduct to the board, money to court. You have walked the complaint process. 10 days to answer, 15 to weigh a consent order, and a majority vote to discipline. You have grouped the 21 grounds into 7 themes you can actually recall, and you have mastered the recovery account with its $1 in, its $15,000 and $30,000 caps, and court-ordered payouts. Here is what I want you to take from today. This domain rewards a clear mental model more than rote memorization. The Commission protects the public, regulates licenses and conduct, and pushes every money question to the courts. Hold that thread, and the specific numbers and grounds hang neatly from it. You're understanding a system, not memorizing facts. And remember those 5 recovery account numbers: $1 in, $30 for a renewal assessment, $500,000 minimum, $15,000 per transaction, $30,000 per licensee. 5 numbers, 5 jobs. When you keep those straight and sort conduct from money, you have turned this domain into some of the most predictable points on your exam. Before you go, grab those free practice questions from the link in the description. With the understanding you have built today, plus focused practice written for this exact Tennessee exam, you will walk in prepared and confident. Review this video whenever you need a refresher, trust your preparation, and go earn that license. You have got this. That wraps up our look at the Tennessee Commission and licensing law. If you'd like some questions to practice everything we just covered, head over to our website using the link in the description. There, you'll find hundreds of free practice questions, plus complete study guides, all ready and waiting for you to dive into and start reviewing today. Subscribe so you don't miss the next part, and good luck on your exam.